An introduction to intellectual property. A summary of patents, trademarks, copyrights, trade secrets, and other forms of intellectual property in the United States. The law in the United States and many other countries provides exclusive rights to a variety of creations of the mind, intangible assets including patents, trademarks, copyrights, and trade secrets. Under intellectual property law, the owners of certain intangible assets, such as musical, literary, and artistic works, discoveries and inventions, words, phrases, symbols, and designs, are granted certain exclusive rights. The owner of the protected property has a right to bring action in court to remedy unlawful infringement of these rights. One of the most important intellectual property rights applies to patents. Patents are country-specific. You can't file for a worldwide patent, but you can file for the same patent in multiple countries. In the US, patents are part of the US federal law and enshrined in the original Constitution. The patent provides the owner with a 20-year window of exclusivity. After the 20 years has expired, the patent goes into the public domain. A patent is a right to exclude. It's not a right to build or market a particular invention, but it provides a right to exclude others from building or marketing that particular invention. Eligibility for the award of a patent in the United States requires that the invention must be man-made. Discoveries of natural phenomena are not patentable, but man-made inventions can be patentable if the inventor was the first to invent, the idea is novel, and is somewhat useful. The US allows the inventor up to a year to file for a patent, from the date that the invention first goes on sale. There are various remedies available for patent infringement from the US Federal Court. The patent holder can demand compensation for damages resulting from past infringement. This is usually calculated as a payment of a reasonable royalty, the type of royalty that the patent holder and infringer might have agreed if they'd had a hypothetical license negotiation. Where the infringement is not accidental, but the infringer was aware of the patent and knowingly infringed, triple damages can be awarded by the court. The reasonable royalty is multiplied by 3 in order to act as a deterrent to willful infringement. To prevent future infringement, the court can award an injunction preventing the defendant from making or selling infringing products in future. As well as taking patent infringement suits to the US Federal Court, the patent holder can take the dispute to the International Trade Commission, the ITC, where imports of infringing product can be blocked from entering the US marketplace. A trademark is a word, phrase, symbol or design, or combination that identifies and distinguishes the source of the goods or services from one party from those of another. Customer confusion is a key factor in a trademark dispute. Is the customer confused as to who is the product manufacturer? Unlike patents, there's no term limit to a trademark. However, in order to qualify for trademark protection, the mark must be used in commerce and it must be distinctive. Distinctive marks can be fabricated, words such as Kodak, or marks that have acquired a secondary meaning like apple. Apple's primary meaning may refer to a fruit, but it's acquired a secondary meaning as a personal computer. When it comes to asking the court to remedy trademark infringement, the registration of the trademark is helpful but not critical. The holder of a common law trademark has a right to file suit for infringement as well as the holder of a registered trademark. Direct copying of the mark is not necessary. Blurring or dilution of the mark is sufficient to bring a lawsuit for trademark infringement. Upon a finding of trademark infringement, the court can require the infringer to pay any profits made from infringement to the holder of the trademark and compensate for any damages caused to the trademark holder's business and reputation. The court can issue an order to destroy all goods containing the trademark and an injunction preventing any further use of the mark by the infringer. Copyright law protects software and chips, as well as books, movies, art, music and other literary works. Originality is required for the work to qualify for protection. Compared with patents, the life of a copyright is quite long. The duration of a copyright held by an individual is the person's life plus 70 years. Corporations don't die as predictively as individuals, so the duration of a copyright held by a corporation is 95 years from its original publication, or 120 years from the work's creation. Copyright law comes up against the right to free speech, and there is a fair use exception allowing copyright material to be republished in certain situations, such as quotations for review in scholarly or technical work, use in parody or satire, brief quotation in a news report, reproduction by a teacher for use in a lesson, newsreel or broadcast of an event being reported, and reproduction in legislative or judicial proceedings. In finding copyright infringement, the US courts can require the infringer to pay the copyright holder the profits earned by the infringer, damages to compensate for losses incurred by the copyright holder, destruction of unlawful copies, and an injunction preventing further infringement in future. Unlike patents that have a 20-year term and copyrights with a term of 70 years from the death of the individual creator, there's no term limit on a trade secret. The Coca-Cola recipe dates back to the 1800s, but remains a trade secret today. A trade secret must be a secret. It must not be of public knowledge or of general knowledge in the trade or business. The holder of the trade secret can ask the court to protect the secret if the owner takes reasonable precautions to protect the secret itself. There are several remedies available from the court for misappropriation of a trade secret. The defendant can be forced to pay damages to compensate losses incurred by the holder of the trade secret, can demand recovery of the profits made from its use, and the court can award an injunction to prevent future use of the trade secret.